everyone to the National Association of Scholars series of webinars on race in higher education, and welcome in particular to our second webinar in the series, The History of Racial Preferences. And the subject, racial preferences in higher education have been a hotly debated topic for more than 50 years. Regents of the University of California versus Bakke, the first major case challenging the use of racial preferences in college admissions, was decided by the Supreme Court in 1978. What brought American higher education to that point? How did racial preferences arise in higher education and admissions? Why were they instituted, and how have they changed over time? I am delighted to have three guests to discuss these topics. David Bernstein, University Professor of Law and Executive Director of the Liberty and Law Center at the Antonin Scalia Law School. Wilfred Reilly, Associate Professor of Political Science at Kentucky State University, and Jonathan Vogel, founder and managing attorney of Vogel Law Firm and former Deputy General Counsel for Higher Education and Regulatory Services at the U.S. Department of Education. Now, the way we have this is normally 12 to 14-minute conversationally toned talks by each of the participants, followed by a Q&A, prompted ideally by questions from you, the audience. You will put these questions into chat or the Q&A button. I can pass them on and will, or they can be answered directly by the participants, who can also talk to one another. All of this will be ideally, good and conversational. Do not worry if your questions don't get answered by the end of the session. I will be delighted to forward any leftover questions to the participants so they can have the option of answering. Please email randall@nas.org, RANDALL @nas.org, and I will forward the email. Also, don't worry if you have to leave suddenly in the middle of this. These are recorded and they will be on the National Association of Scholars YouTube channel, usually within 24 hours, for perpetuity. So anything that gets said, questioned, answered will be available for posterity, for better or for worse. With that, I am delighted to start with Jonathan Vogel. May I ask if you'd be so kind to start?
Thank you, David, and thank you to my co-panelists, and thank you, everybody, for joining us today. It is a real pleasure and an honor to be here. We're going to be talking about the history of racial preferences, maybe with a focus on higher education admissions. And I've been asked to be a member of this panel because I'm going to take us back before Bakke, long before the 1970s. I'm going to take us back to the 1920s and 1930s in connection with the pending cases against Harvard and University of North Carolina. I was asked by the Louis D. Brandeis Center for Human Rights Under the Law and the Silicon Valley Chinese Association Foundation to author an amicus brief to the U.S. Supreme Court that described what occurred at Ivy League schools, Harvard in particular, in the 1920s and 30s to Jewish applicants, and how that conduct and misconduct, I'll call it, is similar to how Harvard, UNC, and most selective colleges are treating Asian Americans today. So I'm going to take us all the way back to the 1920s and 30s. Before the 1920s and 30s, in the 1800s and early 1900s, Ivy League schools, including Harvard, which was leading the way together with Princeton and Yale, were finishing schools. They were for wealthy Protestants. I want you to, Protestant men, I want you to picture, campuses of men and of Protestant men, and these were finishing schools. These were people who came from highly touted prep schools. These were people who were wealthy. These are people who were being sent to the Ivy League schools to become gentlemen, to become leaders. Now, what you didn't hear me say was it was about academics, because it really wasn't. And that's strange for us to think about today, that Harvard and Ivy League schools were not about academics and were not about rigor, because that's not what they were. They were about making boys into young men, socially, athletically. They wanted confident, handsome men. That was kind of the ideal Harvard, the ideal Ivy League student. Virtually everybody got admitted. They had an admission test that was quite easy to pass, and everyone got admitted basically to your Harvard, your Yale, Princeton, Columbia, which were all very expensive. So this was all very exclusive, and these were again finishing schools. In fact, so much so that the students at these schools had derogatory terms for students who did too much studying. It was frowned upon. That kind of sets the stage for the way the Ivy League schools were, in particular in the late 1800s and early 1900s. And then something changed in the 19 teens. There was an enormous influx of immigrants from Eastern Europe. And Jewish Eastern Europeans were coming to America in droves, coming in through Ellis Island, largely settling in lower Manhattan, in what they called shtetls, their little neighborhoods together, their little Jewish ghettos, as they called them. And what they brought with them were old world values of prioritizing education. And Jewish immigrants from Eastern Europe did not look like the wealthy Protestants who were going to the Ivy League schools. They looked different. The skin color was a little different. They weren't kind of raised to be the athletes and the handsome and the all-American boy kind of look. And in fact, back in that day, Jews were regarded as a different race of people. Kind of, today we think of it as exclusively as religion, but there was a time where it was regarded as a different race. And there was a great deal of anti-immigrant sentiment in the country in the 19-teens going into the 1920s, because there was such a large influx of immigrants who were entering the space, let's call it, of Protestant life. But Jews were prioritizing education and were looking to go to the Ivy League schools. And in 1918, 20% of Harvard was already Jewish, which is tremendous when you think about the immigration that had just really occurred in a large wave in the 19-teens. That number of Jews, the number of Jews in Harvard was 3 times that which were enrolled at Yale, and 6 times that which were enrolled in Princeton. And Columbia had high percentages as well. But people started to notice. How could you not notice if they looked a little different? That 20% of the class was Jewish. And there was a real concern at Harvard, led by their president, A. Lawrence Lowell, that there were too many Jews. Protestant students, Protestant families were complaining that there were too many Jews. There's a letter that was sent to President Lowell that said, I went to a football game and there were Jews to the left of me and Jews to the right of me. Everywhere there were Jews. And there was a concern from President Lowell that the increasing number of Jews at Harvard was going to drive away the Protestant students. And this was kind of their, this was their thing, this was their culture. And so this was a real enormous concern of President Lowell. By 1922, Harvard was 21.5% Jewish. So it was increasing. And President Lowell was communicating with people about what to do about this issue, started to talk about the need to limit the enrollment of Jews at Harvard to 15%. It was just a matter of how they would go about doing it. And started to express to people that maybe what they can do is look at the certain characteristics of Jews. It was a matter of, well, do we need a quota or should we do something different? And rather than announce a quota on the admission of Jews to reduce their enrollment, the thought was they could decline admission to a certain number of Jewish applicants who possessed stereotypical characteristics of Jews. That is, President Lowell said the faculty and the governing boards can make a rule that's not so obvious, give the Committee on Admission authority to refuse admission to persons who possess qualities described with more or less distinctiveness and believed to be characteristic of the Jews. This was described as a Jew problem, and Harvard had a special committee that they would look at to deal with what they called a Jew problem. There's no ambiguity about it. This is a history at Harvard that is well documented. It has been admitted by Harvard because the documentation is replete. President Lowell stated at one point that he had, quote, attained by far the most important object, which was that of making substantially every member of the faculty understand that we had before us a problem, and that the problem was a Jew problem and not something else. So beginning in the fall of 1922, Harvard began to ask questions of its applicants for the first time of what their race was and religion, mother's maiden name, father's birthplace, to take a look and determine, what these applicants, who were they, who were they receiving, and in fact, they wanted to go so far so as to focus on knowing the Jewish applicants, is they decided that they would classify applicants like this: J1, J2, J3, and other, where J1 is assigned to someone when the evidence points conclusively to the fact that the student is Jewish, and J2 is assigned when the preponderance of the evidence suggests that the student is Jewish, and so on and so forth. Now, not everybody at Harvard was on board with coming up with some kind of quota. Future Supreme Court Justice Felix Frankfurter expressed some reservations and spoke up about what was happening. But by June of 1923, President Lowell decided that maybe what we need to do is we need to limit the enrollment of Harvard. This is something they had not done before. Why don't we limit the enrollment of Harvard to 1,000 students? If we did that, not everybody can come, and we could be selective. And we could be selective for the purpose of limiting the percentage of Jewish students at Harvard. So what I'm describing to you is the beginning of selective college admissions in America. It started at Harvard and other Ivy League schools for the purpose of limiting the number of Jewish applicants. By 1924, Harvard was 25% Jewish. What was decided in late 1925 is President Lowell said that Harvard needed to come up with a way to examine applicants, and they would be examined based on what he called character and fitness. The belief was by President Lowell and others that Jews simply did not have the character and fitness. That was a stereotype that they were running with, and so it would be very easy to exclude Jewish applicants based on their lack of character and fitness. And the way that they would go about doing this is they would conduct interviews. The admissions office would conduct interviews, and alumni would conduct interviews. At some point, they asked that pictures be provided, all obviously to discover and get as much information as they could about an applicant's ethnic background, to determine who had these traits, the stereotypical Jewish traits. By 1925, Harvard's Jewish enrollment had hit over 28%, and that was its peak. And it was a panic at Harvard. By 1926, they had begun the character and fitness review of applicants, and lo and behold, that over 28% of Jewish students in 1925 plummeted to 15% in 1926, and it remained at about 15% for the next 20 years. Now, if what you're hearing sounds like something that's quite similar to the allegations and the facts that have come out in the Harvard and UNC cases about Asian Americans, I would say you're absolutely right. And in fact, that's the thrust of the brief that we filed on behalf of the Brandeis Center and the Silicon Valley Chinese Association Foundation, that the discrimination by Harvard against Jewish applicants in the 1920s and 30s is no different from what Harvard and UNC and other selective colleges are doing to Asian Americans today, where they have certain personality tests and they're judging Asian American applicants based on stereotypical characteristics. In fact, we're kind of proud that Justice Neil Gorsuch mentioned the issue during oral argument on October 31st of last year, that Harvard has a long history of discrimination based on race against Jewish applicants, and doing it in a way that is quite similar to what they're doing today to Asian Americans. So like all of you, we're eager to see how that case will turn out. At this time, I think I'll turn it over to my co-panelist. I think Will is next in line, and I'd be happy to answer any questions at the end of the program. Thank you very much.
Lovely having you. Yes, and Professor Reilly, you are indeed next on the order.
All right. Well, great to be here. Thanks for having me. Yeah, enjoyed the first speech. So all right, now I can see the screen. I saw a brief video spotlight there. Okay, so I think that I probably have the broadest brief here. I'm not really talking about a specific aspect of the situation around racial preferences, i.e., Jewish kids in Ivy League schools, for example. I'm really doing what I would teaching my Con Law 331 class at K-State, which is overviewing sort of the recent past of the subject, which is an interesting one. And if I have a theme when I discuss racial preferences, it's sort of growing complexity. When the idea of minority racial preference did finally shift from keeping out, if you will, to bringing in, the original concept of affirmative action was really pretty simple. So if you read through a 1960s era speech like Lyndon Baines Johnson's famous Hobbled Runners, the basic idea was that blacks in particular, Negroes would have been the word used at the time, had been treated badly historically in the United States. And so different varieties of preference policies would be tried for a bit to help us out. Affirmative action actually over the years has meant a number of different things. I mean, I think the very original idea actually was that you would simply do outreach to what many people assumed was kind of the large pool of qualified Black people that existed, that was on par with whites in maybe the Black business community, and that had been neglected and that could then be pulled forward into the mainstream. And it turned out that to some extent that didn't necessarily exist. That those Black people that were fully on par with the white mainstream had already been able to find a way up. So affirmative action evolved pretty rapidly into what the term means today, which is large boost racial preferences, which is the sense in which I'm speaking of it today. But the affirmative action policy that was challenged in the first really well-known affirmative action case, Regents of the University of California v. Bakke, or just Bakke, was remarkably simple. And from at least my research, this was pretty typical of the policies that had existed in this sector for the first decade or so of its existence. So within a mid-sized medical school, Bakke applied to UC Davis, as I recall. 20 or so seats were simply set aside for Black students and other minority students. And obviously the thrust of the case was that a white male who was rejected, but who had better board scores than some of the accepted students, sued, leading to the legal matter. But from that sort of came the modern era of racial preferences. And the Supreme Court in Bakke said two things that turned out to be pretty ground shifting. The first is that they hold that you can't have quotas for racial admission. So to some extent, at least in the college and university sector, you can't legally do the thing that really makes the most sense. Admit the best 10% or so of students in the black column, quote unquote, if you want black guys. Instead, you have to at least make a show of treating race as some common language would be one variable among many others. And admissions officers that I've befriended or even dated over the years will, after a glass of wine or two, argue that this was one of the cases that moved colleges toward taking an interest in things like, quote unquote, hip hop musical performance or small boat sailing that just might correlate with being black or a legacy. And to move away from the few scribbled notes I have, I mean, after listening to the first speaker, I suspect that this sort of thing has been quite common for a while. I mean, if you want to exclude students of Jewish heritage, you might note that you were taking in too many individuals from particular neighborhoods in New York City. If you want to admit more blacks, you might discover a sudden interest in contemporary musical performance. I mean, right now, as we look at the cases that are challenging the legality, the constitutionality of affirmative action, I admit to having a somewhat heterodox perspective on this because I don't necessarily think it'll change very much. I would assume that ed is almost immediately going to, higher education is almost immediately going to shift toward a focus on traditionally test score deficient neighborhoods, or an intense interest in zip codes by median income, a rate of fatherless homes, something like that, that's going to have almost exactly the same effect as the programs in place right now. One reaction, in fact, might simply be to abolish testing altogether. And I don't know exactly what kind of system of proportional admission you'd get out of that, but I'd assume that there are very high dollar consultants, Silver and Associates and so on, working on that right now. But at any rate, the second offshoot of the Bakke case was the primary diversity, or diversity as the primary rationale. So almost in passing, what the court says is that the key benefit of race-conscious policies is not just helping blacks or maybe Native Americans, but instead is exposing students to all kinds of people that they might not previously have encountered, whether or not those people as individuals or even at the group level have ever suffered much in the USA. So today, it's a rare college or university, at least in my experience, that doesn't at least try to have a student body that closely mimics the overall population demographics of the country. So even where minorities in the classic sense of that term, blacks and so on, are a focus, historical oppression is not. So a Nigerian lordling would fall into the black group. Spaniards from Europe are considered Hispanic at about 75% of the campuses in the USA at present, and so on down the line. One of the other panelists might correct this exact number, but at most Ivy League colleges, according to Espenshade in 1998, something like 68% of all Black students are of African descent, are of first-generation Caribbean descent, or are biracial. So virtually none of them are poor or working class African Americans. A term you might hear is ADOS, American descendants of slaves. Whereas obviously a huge chunk of blacks, about 40%, still fall into those two categories at the lower end of the economic spectrum. So do well over 10% of whites. A great book called The Privileged Poor discusses how that entire population, black and white, is almost absent from contemporary American elite education. But in the educational sector, which is obviously the focus of my 12-minute talk today, subsequent cases have largely confirmed these policies. Diversity is the primary goal, quotas fall foul of the law, so on down the line. So with Gratz and Grutter v. Bollinger, we see again this sort of judicial distaste for anything that looks like a hard, logical number. So giving minority applicants 20 points on the application blank is forbidden, but if I recall the language correctly, a holistic policy that prioritizes human uniqueness is not. Fisher v. Texas, much the same. There's some tee-heeing in that matter about whether a policy that allows automatic admission to a good state university for the top 10% of in-state graduates is a quota. Does that constitute a quota system? But again, quotas are frowned upon. And again, the goal of modern affirmative action is diversity. So that one footnote in the case notes that recent Mexican immigrants count for diversity purposes, a bit crudely put, but the goal is a multicolored range of faces on campus. So essentially, the status quo in education right now is that diversity involving large numbers of minorities is a best practice, one. Two, it doesn't much matter whether these individuals have suffered in the past in the United States at really the individual or the group level. You would qualify as a Hispanic for essentially all US affirmative action benefits if you immigrated here yesterday from Venezuela. And three, efficient quotas that might make this happen rather simply are technically illegal. They fall at the strict scrutiny bar. So it's an odd system. And as we see with the current cases involving Ivy League universities, as well as the University of North Carolina, this system is now in a unique place because it is as unpopular with many minority groups as it is with whites. So it can sometimes be challenging to break all of these groups out from larger categories like Asian American, Black, and so on. But so far as I can tell, doing research for academic articles and the like, the highest scores on today's SAT belong to East Asians, South Asians, for example, Indian Americans, Jews, and West Africans. So except for the last group, who could maybe snaffle up some of the Black spots, the sort of rough proportional representation that most of education is trying for hurts those groups as much as or more than it does whites. So we now face the reality of policies which were originally designed to help very specific minority groups, which then sort of expanded grandly, now being challenged by other minority groups which they hurt. And I think in the future, when you see cases brought against affirmative action policies, the plaintiffs will almost invariably be Asian American, Indian American, Southeast Asian American, so on down the line, because there's the sympathy level there is much greater. There's no plausible way to claim that gaps in performance between Japanese Americans and Mexican Americans are due to racism, whereas that argument can still at least plausibly be made when it comes to gaps between Anglo-Americans and Black Americans. I will say this is not the focus of my talks, a minute here, but all of this is complicated even more by the reality of affirmative action in the business world. So, I mean, there's an entire set of cases on point there as well that we've seen develop since the 70s and the 80s. Our Richmond v. Croson, for example, is an obvious starter point. So there's no strong diversity rationale when it comes to hiring contractors and so on. You can't just privilege a specific number of minority businesses. However, you can engage in very specific targeted affirmative action hiring if any past discrimination at, for example, the municipal, the city, or the township level occurred that your entity was responsible for. So there's now an entire industry of consultants dedicated to sort of going out there and finding that the city of Miami or the county of Dade or whatever was guilty of the most heinous form of discrimination in the past. And all of this ties into discrimination law in general. I mean, we have sort of a weak proportional representation standard in the USA, where if you fall short of 80% perhaps in one sector of the workforce of the expected representation of Blacks, Hispanics, I would assume whites, that you would presume looking at the population of the area where you work, that's at least the theoretical basis for a lawsuit. So, I mean, the actual picture here, again, is pretty complex. And again, it's not necessarily focused on Black people or the groups that you might think have faced historic discrimination in the USA. A minority contractor today could very easily be someone who's 1/16 Cherokee Indian. So again, the theme of my short talk would be vastly increasing fractal complexity growing out of a very simple and perhaps initially good idea. And like the first speaker, with that, I'll close. And again, I'm more than willing to take questions at the end of everyone's presentations.
Thank you so much. Wonderful. We're going to turn to our third speaker, David Bernstein.
Thanks. So I am approaching all this from a bit of a different angle. So I've written a book about classifications, racial classifications in American law. And usually when we think about racial classifications in American law, we think about the Jim Crow South and their sort of absurd permutations of how much Black ancestry you need to be considered Black, whether it's 1/4 and you're a quadroon, or 1/8 and you're an octoroon, or one drop and the one drop rule applies, or whatever. And we look back with sort of revulsion, horror, and it's somewhat a little bit almost humorous if you could get past how awful it was that people went to these lengths to try to classify people. But we don't really think of having racial classifications by law in the United States now. We sort of accept the idea that there are these 5 major groups: Blacks, whites, Hispanics, Asian Americans, Native Americans, and somehow this is just kind of natural and inevitable and just sort of arose spontaneously. But in fact, all of these classifications were invented for legal purposes by the US federal government in probably the most important obscure rule that you've never heard of, called Statistical Director number 15, which was enacted in 1977, and it was done for benign purposes. Basically, federal agencies were collecting data on education, on civil and jail, prisons, on civil rights, employment, and so forth, and they were getting inconsistent data because there was no formal way of classifying different people. So what we now call Hispanics, one agency might have been collecting data only on Mexicans. Another might have been collecting data on Mexicans, Cuban Americans, and Puerto Ricans. And another might have said those and others. Some might have used Spanish-speaking households. Some might have used Spanish surname, and so forth and so on. And eventually the government said, okay, we just need to regularize the statistics, not really for any particular purpose other than making our data consistent. And for the purposes we're using it for, anti-discrimination and tracking progress, they don't really have to be that exact. And indeed, they cautioned that these the Office of Management and Budget, which promulgated the rule, said these are not meant to be anthropological or sociological. They're not meant to be scientific, certainly. They're not meant to be used for eligibility for any programs, which would mean they're not to be used for affirmative action. And they got very little attention at the time. You go back to the newspapers, no one was talking about this because no one really thought that this was especially important. But it turns out, as you might expect, that once the government had promulgated these statistics and they became part of all the forms we fill out all the time and became part of the census and so forth and so on, that they started to seep into all aspects of American life, including university admissions, including minority business enterprise programs, including all sorts of other things. In fact, people even began to think of themselves as Hispanics or Asian Americans to some extent, whereas previously those classifications barely existed. No one really thought of themselves as Hispanic back in the early 70s. So my book goes into the history of these classifications, how they're defined by the government, and how they're enforced when, as sometimes happens, it's at issue whether someone really belongs to a particular category or not for legal purposes. But rather than summarizing the book at length, I thought I'd just go through a few bullet points of things that we could talk about for further discussion. So some of the anomalies or oddities of how we classify by race by law. So one issue that comes up immediately is why we classify by race or Hispanic ethnicity, but not any of the other ethnic, religious, or minority subgroups we have in the United States. And part of the answer, and they're all protected by the 14th Amendment equally, by the way, there's nothing in the Constitution that singles out any particular groups, much less, for example, Hispanics. But part of it was a sense at the time that race was the big issue in American life rather than religious discrimination or ethnic discrimination. But also, it turns out that in the 1950s, when the government first started classifying people, even though they didn't have uniform classifications, there was a very strong norm supported very much by the NAACP and the ACLU that you don't ask someone what their race or religion or ethnicity is, because that would lead to discrimination. So if you were a government contractor and you got a form from the government asking you how many minorities do you have, prove to us you're not discriminating, all you could do is really look around the room and say, well, that guy looks black, that one looks Mexican, that one looks maybe that they're Native American or something, and that one looks what they used to call Oriental, and you put those down. Those are the classifications that became the baseline for what we do today. So there's no real logic to it. There's no one really sat down and explained why we don't look at, anti-Armenian discrimination or anti-Italian discrimination. There was some arguments about that, in fact, but it was mostly just happenstance. For that matter, why do we have a Hispanic classification? If you're looking racially at people who look like dark-skinned Mexicans, how did that morph into the Hispanic classification? Well, they added Puerto Ricans because Puerto Ricans are often very dark-skinned. And then in the early 70s, when they were deciding how to formally uniformly use racial statistics across the government, Richard Nixon was looking into it. He said, wait a second. We're giving potentially affirmative action preferences to Puerto Ricans and Mexican Americans, but they vote for Democrats. Cubans, who are overwhelmingly white identified and look European for the most part, are not included. That's wrong. They vote Republican. We need to include them. Once you include Cubans, you basically have to include anyone of Spanish-speaking origin because you're already including a lot of white people. Relatedly, when we started in the early 1970s trying to formalize these classifications, South Asian Americans, in other words, Indians and Pakistanis and Bangladeshis and so on, were classified as white. I cite in the book government rules saying people from this part of Asia are classified as white. But there was a small Indian American lobbying group, and they say, wait, we see that minority business enterprise preferences are going after people. A lot of Indian Americans own small businesses and government contract businesses. We want to be included in that classification. And no one else really objected because there were very few Indian Americans at the time. So they basically just sort of arbitrarily moved them into the Asian category. Similarly, people at the time said, wait a second, why is there a white classification? Isn't that kind of just made up? What do people from Yemen have in common with people with descent from Iceland? Or what about regional ethnic groups that have historically faced discrimination, like Portuguese in New England or Cajuns in Louisiana? And they made the argument and they were kind of ignored. The classifications, by the way, are mutually inconsistent. One of the oddities are that American Indians are defined by cultural affinity, Blacks and / African American by race, Asian by geography, and Hispanic by language and culture. If you're Hispanic and move to Asia and then your family comes to the United States, you never become Asian because you weren't geographically based there originally. But if you're Asian and move to Latin America, then to the United States, you become both Asian and Hispanic. American Indian groups have been very protective of their turf, ensuring that even Latinos of 100% indigenous origin are not classified as Native Americans or Indians, and also that Native Hawaiians, who eventually got their own classification, are excluded from the Native American classification, even though there's a pretty strong analogy between Native Hawaiians and, say, Alaska Natives and American Indians. We have a mythology in the United States, which is promulgated, by the way, in a lot of law review articles, that it's all self-identification and no one ever challenges anyone's race. And that's not quite true. It is true that it's generally self-identified and usually no one checks, but it is also true that there are cases, I identify several dozen in my book, where people's racial or ethnic identity that they've checked on a box have been questioned, mostly for purposes of minority business enterprise programs. And I have to say, the hearings that go on in these agencies and in courts as to what makes someone truly Hispanic or truly Black or truly Asian is really distressing and really reminds me of the race trials of the 19th century. Do they look like a member of the group? Do other people accept them? How do they dress? What's their last name? Do they have an accent? All these things that we think maybe we got past in the 1930s or 40s or 50s, we've actually brought back. Common errors are made by the average person. It's weird when you check off these forms, including on the Common App for colleges, they give you the names of the different groups, but they give you either a minimal or sometimes no explanation of what these classifications mean. So a lot of people think that Arab Americans are not classified as white, but they are. A lot of people think that if you're from Egypt or you're a white person from South Africa, you can classify yourself as African American, but technically you're only supposed to do that if you're descended from one of the Black racial groups of Africa. But again, we have this weird system where we rely on these classifications, but the vast majority of people, including me before I wrote my book, really have no idea what the scope is. A lot of people also think, for example, that Brazilians are Hispanic/Latino and people from Spain are not, but actually it's the opposite. A majority of people, even though some people now consider themselves Asian American, the majority of people who are in the Asian American classification don't accept that identity, even as a secondary identity. Hispanic/Latino Americans will generally accept Hispanic Latino, but not Latinx as a proper identity, but they mostly prefer to be known either as just American or being a descendant of whatever national group they're from, Mexican American or Guatemalan American. So while universities treat Hispanics and Asians, and for that matter, whites, as being uniform cultural groups, even people within these groups themselves typically don't think of themselves that way, or at least not primarily that way. And of course, there really is nothing that an immigrant from Spain has in common with an immigrant from a rural Mexico who is of 100% indigenous descent, who doesn't even speak Spanish, nor does someone from Pakistan have anything to do with someone who's from the Philippines. This is all completely arbitrary. And, when I wrote the book, I thought, oh, this is going to be so controversial. Everyone on the left is going to hate this. But as Wilfred mentioned, this is becoming controversial within the community of people who typically supported affirmative action traditionally, because so many of the benefits now are going to people who they were not really intended for. He mentioned that universities, a very large percentage of racial preferences for African Americans go to immigrants and their children. 21% of the African American population is first or second generation immigrant. They're a much higher percentage of the population of students at places like Harvard. And for that matter, a lot of the preferences are now going to Hispanics, many of whom are white, and almost all of whom, a vast majority of whom are post-1965 immigrants. They never suffered under the equivalent of Jim Crow or other racist policies because they were here after the Civil Rights Acts. And in the minority business enterprising context, unlike in universities, so say an immigrant from India or Mexico who's been here for 6 years and has gotten citizenship gets exactly the same preference as a descendant of slaves who grew up in inner city Baltimore. And as a result, the vast majority of minority business enterprise preferences are going to immigrants and their recent descendants, and not to the sort of people it was intended for. And it's all become sort of a scam. People will list their wife as the majority owners to get women-owned preferences. People will pay money to join an Indian tribe so they can list themselves as Native American. And there's a huge amount of general corruption and going on there as well, which has made people very cynical about the whole project. And the final thing I want to say is that while we have all come to accept, I don't accept it, but while we have generally come as a society to accept these classifications as being normal and natural, I really want to emphasize that when these classifications were promulgated, not only were they not thought to be especially important, but it wasn't like they gathered a bunch of experts in sociology and anthropology and linguistics and genetics and all sorts of other things and ethnic studies and put them together and said, let's really figure out what the different American groups are. They really did it in the most haphazard, arbitrary way you could possibly imagine. So when the Hispanic classification was being created formally, what the committee in charge did literally was they asked for a volunteer from the government, one Cuban American, one Puerto Rican American, one Mexican American to represent the three largest ethnic groups of Hispanics in the United States, put them in a conference room for a few weeks, said, you hash out what the name of the classification should be and what its scope should be. And they decided on Hispanic, so it did include Brazilians, did not include Brazilians, did include Spanish, could just as easily have been the other way, could have been more like a mestizo category that only included people of mixed race heritage, but just completely arbitrarily, they did so. Later, in the late 1980s, when African immigration was picking up to the United States, OMB was asked, should we include African immigrants and their children, Jamaican immigrants and their children in the African American category? And they just said yes. I mean, they didn't like hold public hearings and talk about it, just arbitrarily said, yes, just include them. So all these classifications have been done in a way that courts were going to take seriously, not just the issue of whether there should be preferences based on race, but whether the preferences we have based on these categories make any sense, and wherever supposed to make sense, because again, they weren't meant to be affirmative action categories. I think they couldn't meet even the lowest strand of scrutiny. I said that was the last thing. One more tiny point. The classifications are also now used, this may be of interest to anyone listening who's in the scientific field, in science and biomedical studies by fiat of Congress, and then the FDA and NIH said we have to, Congress told us we have to use race. We'll just use these Directive 15 classifications. What sense does it make if you're doing a scientific study on any basis to put Pakistanis and Filipinos in the same classification for biomedical purposes, or put someone who's of Spanish European origin in the same classification as someone who's half Black and half Incan and moved here from Latin America? There is none. It doesn't make any sense at all. The fact that we've gone on and done this without there being a huge public outcry from the scientific community, from anyone with any really common sense, is just a testament to the fact these classifications have come to be seen as natural and inevitable, when in fact they're entirely arbitrary and not just socially constructed, but legally constructed by the government. Thanks.
Thank you so much. Thank you all very much. Now, I encourage people to send in their questions, and we already have a whole bunch. And again, I don't do them in any particular order, but George Seaver, when did Harvard change from a local entrance exam to a national test to achieve a national student body? Is the first question coming up.
Yeah, they changed their test sometime in that 1920s to 1930s time frame, I think, to when they limited the student body to 1,000 students. They made it more selective to get in, and they examined character and fitness.
Thank you. Anybody else on that? Or I will go from Patrick, a question. Did any admission officers speak of the educational value of diversity before the Bakke decision?
If I can comment on that, I'm sure the other panelists have some knowledge as well. I certainly, in my reading and research, haven't seen a lot of discussion of it. I mean, if you read something like Hobbled Runners and the response speeches, I mean, the argument for affirmative action was very, very simple. I mean, we've done bad things to minority groups in this country, primarily African Americans, and we should fix those by giving a temporary advantage, a hand up. You know, you don't take someone who's been shackled for decades and put him on the starting line of a foot race and expect a fair competition. I mean, these are well-known quotes. And when cases came up involving the first affirmative action programs, I mean, that's when you began to see, at least in my experience, discussions of the value of diversity per se. So, I mean, I really noticed that with Bakke. This is actually kind of the shell game, I think, that was played with affirmative action. The argument for affirmative action to most people prior to Bakke was, we're going to do a bit to repair the past. That wasn't necessarily the rationale that the justices went with as a justification for diversity forward programs in that case. So from that point forward, you started seeing people try to claim that all along the goal had been diversity. But I mean, that brings up what David began to talk about. I mean, the argument that any sort of racial representation then confers the same advantage. So you get just as much of a diversity benefit from having a Haitian classmate as you do from having an ADOS Black classmate. However, the Haitian classmate hasn't historically suffered much of anything in the United States. So yeah, I think that this is a dramatic shift that at least I saw in the legal reasoning that began at a specific point. I don't think that anyone in the 1960s was arguing that the reason for affirmative action programs or diversity forward programs was that we'd be sending kids to a more diverse college environment or anything of that nature.
One of the great ironies that I love to point out is that the first case involving affirmative action to come to the Supreme Court was a case called DeFunis. I think it was versus University of Oregon. and that case was eventually dismissed without deciding it. But in that case, the plaintiff, Mr. DeFunis, I discovered in my research, he was actually a Sephardic Jew who is the descendant of Turkish immigrants to the United States. I actually was in touch with his granddaughter, who told me that Mr. DeFunis's grandparents actually spoke Ladino, which is, I never learned English, which is the language of Sephardic Jews, a Spanish-based language. So Mr. DeFunis nowadays would have been a defendant rather than a plaintiff, because he would claim I'm Hispanic and I get preferences. But that particular program was limited to Negroes, as they would have called it at the time, African Americans. So he was on the other side of it. One additional point I wanted to add is that at the time of Bakke, Bakke was a medical school, so there was another rationale that was used for affirmative action. It wasn't diversity. It's a little bit more persuasive in a way, which is that they said, well, most white doctors, very few white doctors are going to be willing to practice in somewhere like Watts or other poor Black neighborhoods in California. So in order to make sure that we have sufficient numbers of Black or Hispanic doctors, Mexican doctors are willing to work in these neighborhoods, we should have this quota. Now, of course, the counter argument was, well, you could just require that you could have certain scholarships or certain special admissions for people who agree to serve in those neighborhoods without having racial quotas. But that there is something to that particular argument. I think it is true, in fact, that you are much more likely to be willing to practice in a poor Black or Hispanic neighborhood if you were from a Black or Hispanic background.
There actually, that's an excellent point there, but there actually is one ironic caveat to that. A couple of Black political scientists and economists have looked at that, and that does not appear to be true. I myself wasn't aware of this until about a year ago, but actually Black doctors and lawyers seem to be slightly more likely to go the big firm, big hospital route, because they, or we, I guess, are much more likely to be very highly recruited. So, I mean, immediately after Harvard University, when you're talking about campuses that get the most legal, most medical recruiters, you've got Howard University. Kentucky State, where I teach, is a perfectly solid school, but is in the top 20 in terms of people coming in, recruiting for graduate schools and so on. So a lot of these people that are getting affirmative action benefits, and I mean, you're absolutely right about the rationale, about the argument. I hadn't, in fact, even mentioned the case. But a lot of these arguments seem to be factually untrue. We're bringing in more diversity. Well, yes, but you're bringing in a diversity of foreign lordlings. Well, we're bringing in more people that are going to work in the community. Well, no, they're not. I mean, they're going to, go back to powerful foreign countries, or they're going to work in big firm law. So, I mean, empirically discussing the testing of some of this is almost taboo in my experience.
I just want to add that in Bakke, actually, the decision cites to Harvard's amicus brief in Bakke and the Harvard plan. And so Harvard was actually held up at the time as a great example of how race can be used, and not necessarily because there was past discrimination at that particular entity. There was a line in the Harvard amicus brief that says a Black student can usually bring something that a white person cannot offer. So the court did kind of cling on to this, Harvard plan and hold that up as the ideal of using race as a factor for what would become known as the diversity rationale.
If I could add just one point about that, I mean, Justice Powell wrote that concurring opinion in Bakke, and he was he was moderately conservative, a real establishment guy. He'd been head of the ABA, partner at a big law firm, and he trusted the likes of Harvard to have some basic honesty and integrity. So he said, they have this diversity program. He wasn't thinking, this is really meant to keep out Jews, and he assumed that if we say you're allowed to use diversity, but only for this narrow purpose, that universities would actually more or less stick to that honestly. And what we've seen really over the last 45 years, is that if you tell universities you're allowed to use race for this narrow purpose, they'll say, what you really mean is as long as we don't use explicit quotas, we could do whatever we want. And I think at some point, the court has gotten, especially it's gotten more conservative, but I think also they've sort of gotten tired of it. If you listen to or read the oral argument, they're trying to explain things like, well, we don't use race this way, so it's not really important. But if we don't use race, we won't have any minority students. And the justice is like, you can't have it both ways. Either you use it as a major factor or it's not important. It can't be not important and you won't have any minority students if you don't use it. And they were talking just double talk and gobbledygook. And I think it wasn't really persuading anybody at this point.
Yeah.
I was going to interrupt to go to another question. Do you mind if I, sorry, I'm being a tyrant here. Ken Masugi has a pair of questions I want to pass on. In his questions, in his 1912 presidential campaign address, What is Progress, Woodrow Wilson described his task as president of Princeton to make his students as little like their fathers as possible. Was that a prevalent attitude among Ivy League presidents at that time? The attitude is reflected in Wilson's US presidency, attacking the Declaration of Independence and thus separating Americans from the founding fathers. Followed up by, Wilson was not a friend of Jews, blacks, immigrants, but the elite attitude continues. Comments?
Yeah.
20 and all.
Yeah, I would say that Princeton was maybe chief among the elite Ivy League schools at the time, to have kind of a country club atmosphere. I know it's kind of funny to think about that today, but that's what it was like back then. And as I recall reading, it was Woodrow Wilson who was trying to bring some academic vigor into Princeton, and he was, and there was a lot of pushback. So, for example, he wanted to, I think, limit or eliminate the, I think they're called lunch clubs or eating clubs at Princeton that still endure today, that are a very, very big deal, a very big part of the social life, on par with fraternity life at other schools. And there was just a ton of pushback from Princeton alumni. But as I recall reading, Woodrow Wilson, as president of Princeton, was trying to bring some academic vigor to that university.
My daughter is a high school senior, so I've been going through the college admissions process. And the most remarkable thing about it to me is how many colleges try to recruit her and other students, not by saying we're gonna make you different than your family, not by saying we're gonna challenge your ideas, but you're an activist, you already know what the right things are, and here's how you could come to our school and learn tools to use that activism to make a better world. And I'm thinking, my kid's 17 years old, she's brilliant, but she doesn't know that, she's not a fully formed intellectual, and the role of the university should be not to tell her how to think, but at least to make her question what she believes and try to justify it, rather than to just sort of tell her how great she is and how she's already a brilliant intellectual and all she needs is some tools. So I think to some extent we've gone to a consumer model, and the consumer, being 17-year-olds, are quite more assured about their own perspicacity than they really should be.
Yeah, I mean, I would agree with almost all of that. Now, first of all, I'm a little surprised to hear that quote from Woodrow Wilson. And you almost want to make jokes like, was he wearing his Klan robe when he said it? You don't think of Woodrow Wilson as necessarily the most red-eyed revolutionary in the game. But no, I think that attitude, the line, I will make you very different from your father, is very, very common among the American quote-unquote intellectual elite. I could imagine 10 or a dozen figures I've met in Ivy League or Big Ten academia saying that today. Tom Sowell wrote an entire book about this called The Theory of the Anointed, where he argues that, the growing pace of knowledge acquisition in modern society makes many people think that they can do something that's never been done throughout human history, which is totally and rapidly recreate, well, how would you put it, societies and human nature. And I mean, I would say to some extent, this is what's being pitched to your kid. It's sort of commodified revolution, like everything they've been telling you is wrong. Come here and learn what's right. I mean, the colleges definitely, sometimes including mine, do fall into the pit of doing this. So I think that the attitude does endure. I actually think that there's a very serious problem with it, which is that teaching only critical theory is sort of a useless veneer unless someone is previously aware of the theories that the crits were criticizing. This is the major problem that I notice with a lot of students. They're very aware of a lot of trendy revolutionary ideas. They're not aware of the arguments for sort of eternal grace and beauty and so on from, Augustine or Aristotle or much more modern, perhaps relevant individuals that were being criticized. So whether the line of bull that's being sold is useful is a question to debate. I would take the home position of no, but yeah, it's definitely still out there. interesting to see it go back more than 100 years to someone we would now think of as, a racist man of the center right, but not entirely surprising.
I want to have two quick comments to add to this. First, on the whole diversity and Bakke, I wanted to do a plug for, strangely enough, NAS President Peter Wood's book, Diversity, the Invention of a Concept, which goes into this very issue, and indeed, I think, shows that diversity is almost exclusively coming out of that legal decision. I just also wanted to mention from family history, my granddad taught at Columbia in the 1920s, and I do believe there is a family memory that the point of the Columbia core curriculum was, quote, to make students stop believing in the Bible, unquote. So yeah, there are echoes of this attitude. I wanted to go from those comments to a question from Greg Schuckman, if I may. Affirmative action discussions seem to focus almost exclusively on race, but there are many other classifications that could be subject to discrimination: disability, socioeconomic status, gender identity, etc. Will the SCOTUS cases address the broader categories, or will they only be limited to discussions of race?
Well, as the lawyer here, a law professor here, I'll say that the other classification, the only groups that Harvard and UNC kept official track of as they were going through their admissions process was how many they had of the official racial minority groups plus Hispanic, which is an ethnic group. They don't keep track of how many transgender students they have. They don't keep track of how many disabled students they have. They don't keep track of, they keep track later. They sort of keep track of how many students they have who have Pell Grants, but it's not really a factor in admissions. They just like to brag about, we're not just reproducing hierarchy, that's largely what they do, but we also have X% who are Pell Grant recipients. But those would be less controversial legally because there's no strict scrutiny involved under Supreme Court precedent, but more important, they're just not an issue because there's no explicit preference being given to those groups. If you tell a story about how you overcame your disability and so forth, that might help you on your essay, but they're not at the afternoon or weekly admissions meeting saying, hey, we now have 4% disabled students, so we met our goals, so we can relax a little bit, the way they'd be saying it with Hispanic or Black students, or worse yet, oh wait, this student seems really good, but we already have a lot of Asians this year.
Yeah, I'm not a practicing lawyer right now. So, I mean, again, might be comments about this on the panel, but a lot of this would seem to get into what are actually protected or considered classes. I mean, so race is, a legally protected class. Like, race is taken into account, obviously, in collegiate admissions. A lot of this other stuff, whether people are gay, for example, the fight about the Equality Act and about the ENDA, the Employment Non-Discrimination Act, to a large extent actually centers on whether you're going to basically add sexual orientation to the Civil Rights Act. And that might change some of this. But in practice, as David said, there are no affirmative action programs targeting gay people, and there aren't a substantial number of legal protections. You can, in general, fire someone in the United States for any reason or no reason at all, unless they fall into certain protected categories. Homosexuality is not, at least outside of the federal government, as I understand, one of those protected categories. So unless you're considering that to the same extent that you're considering race, no, you're not going to have discussions or debates with the same level of intensity that you would surrounding race. Same with the trans issue. One quick thing to add there, social class to me is the elephant in the room of virtually every American debate that we completely ignore. So social class is not only not a legally protected category, but no, I don't think we're ever going to see a major affirmative action conversation surrounding social class. The large majority of students at every Ivy League institution would be upper middle class on up. I forget the figure, but from middle class on upward is easily 75+%. So I don't think you're going to see those institutions try significant outreach. And I'll actually shut up and condense this to one sentence. The reason no one likes class-based affirmative action is that it doesn't benefit anyone with a horse in this race. Most of the Black parents sending kids to Harvard are rich, and they support race-based affirmative action because it gives well-off minorities a pretty significant advantage over well-off whites. I mean, most of the white parents sending their kids to Ivy League institutions are doing pretty well. So, I mean, there's really no one who wants to give, what would it be, 135-point boost to working class white and Asian kids. I mean, obviously, if you did that, that would substantially reshape upper level education in the United States. If you gave the same boost to working class kids that you give to blacks today, you would see a dramatically different picture at every one of these institutions. But it's not the picture that anyone would necessarily want. You'd see fewer black people, you'd see fewer Hispanics, you'd see fewer legacy whites, and you'd see a lot of members of groups that are considered, forgive me, kind of non-trendy. Southern whites, recent Asian immigrants, Russian Jews that can, and I'm speaking in someone else's voice here, but barely speak the language. That's what you'd get. So, I mean, there's no push for that at all.
Let me just.
I love it.
I can't help mentioning, oral arguments in the Supreme Court aren't usually funny, but I did laugh out loud at one point in the Harvard case where Harvard's lawyer said, "Well, we're really concerned. We don't just care about race; we care about socioeconomic diversity. Almost half of our students get financial aid." And I'm thinking that means that over half of your students could afford $85,000
no financial aid
for 4 years
at
out
all.
of pocket, which is not. I don't know what the figure is in the population as a whole who can afford that, but it's a lot less than 52%.
Yeah, David, Randall, let me just add that the cases at the Supreme Court are only about race. And so the decision that's going to come out, the holding, is going to be about race. As David Bernstein said, the examinations was under strict scrutiny, and that's a constitutional standard that the court has held applies to race for Equal Protection Clause and Civil Rights Act challenges. However, I do think that a decision, let's say, that says that colleges cannot use race in admissions under some diversity rationale, I think that does send some shockwaves that colleges best not come up with some policies of admitting students based on other areas, sexual orientation or gender identity, for the purposes of diversity, even though those classifications would get a different level of scrutiny. I think it sends the message that this is not how this works. We don't judge people by those types of characteristics as far as admissions for some diversity rationale. But what it also does is then it makes, I think, the students' essays so important, because you could have a university that says, all right, we don't take race into account, but we are looking at essays. And if someone describes how they overcame challenges, they overcame obstacles that they think were there because of their race or because of their sexual orientation or because of their gender identity, oh, those are the kinds of essays we want to see, right? Those are the kind of obstacles that are impressive to us to overcome. And it'll be interesting whether lawsuits are brought on that, alleging that this colleges are doing the same old thing, but they're just masking it with college essay review.
Thank you. I want to go to a question to which I want to actually add some stuff of my own and sort of push it for a slightly different question. Deborah Glazer, I hope you will forgive me as I brutally alter your question. She asks, what is Jewish enrollment at Harvard today? I had read that it is at or below 10% now. What I want to add to that is, some information from Pew Research on the rate of intermarriage on Jewish Americans, which I think makes that question impossible to answer yes or no. The rate of interfaith marriage among non-Orthodox Jews is now 72%. The number of Jewish adults age 18 to 29 who are the children of interfaith marriages is already 46%. In effect, you can't even identify a coherent body of people as Jewish Americans anymore. I'm mentioning all this to, in effect, say, does this not illustrate the point that these racial classifications are becoming bizarrely irrelevant to the vast majority of modern Americans as they become bits of everything? How should I put it? If a majority of people are a bit of this and a bit of that and a bit of the other, how on earth, even on its own terms, how can isn't the system going to collapse under its own weight?
It certainly seems to me that in the minority business enterprise context, it already sort of is, in a sense. that over 50% of Americans can claim one of the categories already, that they have Hispanic, Black, Native American, or Asian ancestry. And then in a generation will be even more if you add fraudulent claims to that, or exaggerated claims. If everyone's getting affirmative action, then no one is. In the context of universities, it's all self-identified. And we do have this phenomenon of what we call identity entrepreneurs in the legal academy, people who, might seem to be white socially to other people. They don't have any characteristics, be it looks or cultural connections or so forth, that would make them a quote unquote minority, but they have a plausible claim under those broad definitions that we mentioned to write down that they are one of these categories. I was just writing about this for Glenn Reynolds' Substack. When I was in college and law school, my strong impression was that people were pretty conservative about claiming minority status. That people who were against affirmative action, who could claim it but not really, they said, well, I don't really like affirmative action, I don't want to benefit from this. People who are in favor of affirmative action say, well, yeah, my grandfather was from Spain, but that really isn't meant for me, that's meant for poor Mexican kids or whatever. And my impression now, though, is that so many people are claiming and getting preferences who are really on the margins of the group category, that everyone's just grown very cynical about it. And the advice you'll see on Reddit threads and so forth about college admissions is, if you could claim it, claim it. If they don't want to, if they decide you're not really Hispanic, that's on them. But if you have a Mexican great grandfather, why not put it down? So I don't even know how reliable these statistics are when we see X percentage of students at this school or that school are Hispanic or Black, or what percentage of those people would we not, in a common, social environment, believe belong to those classes. And the one big statistic I have, which I don't think is as true for the other categories, but there is evidence that about 10 times as many people put down their law school applications that they're Native American as who put down their lawyers who are Native American later. So basically we have, for every 10 people who write they're Native American when they apply to law school, only one of them really considers himself Native American when no one's looking and there's no benefit to saying so.
Yeah, I mean, my own opinion is not that was not witty and cynical, but my own opinion is purely cynical on this. I mean, I'm not necessarily sure that for at least a generation plus you're going to see any effect. I mean, so for example, these categories in the USA are social constructs to a huge extent. I mean, I identify as Black, but I've taken my 23andMe. I'm actually 40% Celtic, 40% Bantu Black, and 20% Plains Indian. So I mean, I would certainly encourage my son, who would probably be 20% African American, to check the black box. So I think that for a great number of people, if you're 1/16th Cherokee Indian, a la the quote unquote joke I made at the end of my speech, you would be certainly within your rights and probably quite likely to, in practice, say you're a minority business contractor. I mean, to some extent, the end game goal here might be the dissolution of these programs. If we become a country that's 55% technical minority plus the obvious 50% female and so on down the line. But I will say one thing while we're bringing up some of the stats. A guy I sometimes spar with online, Dr. Ibram Kendi, a bit to the left of Castro, actually did some of the best methods work of his career, in my opinion, and looked at this and found he really crunched the numbers across a series of college applications and found that, as far as he could tell, about 34% of all white applicants to college were lying. They were claiming things that just weren't feasible. If you looked at the size of native tribal registries, they were saying they're Native American, an eighth Hispanic, things like this. And he actually, I mean, the data still, the article itself is up, but he took down the tweet about this and so on, because the reaction consisted largely of people on the right saying, so how about that white privilege, huh, Doc? And arguing with him for, hours of 2-3 days running. But the point, I think he was correct about the point, academic sparring aside, a third of students are perhaps saying they are things that they are not in any visible sense. Is there any reason for that to stop if you still have an advantage over 2/3 of the students? Well, not really, in kind of a game theoretic sense. It may be a bit unethical, but I think for 20 plus years, you would still see this, unless, again, we say, well, this is ridiculous. The country is now, I mean, the country is 40% minority. I mean, formally speaking, we're 59% 59% non-Hispanic white. So unless we make some changes to these programs based on that reality, I think what we're seeing now is going to go on for some time to come.
Yeah, and let me just quickly add, at the oral argument in the Harvard and the UNC cases, one of the justices, it might have been Justice Alito, I can't recall, was asking questions about this, was asking about, what does it take? If is it enough if your grandparent is Native American? What about just one great-grandparent? What about just one great-great-great-grandparent? What about, and he stopped himself and he said, what if it's just family lore? No one really knows, but we kind of talk about it in the family. Is that enough? And the lawyer from Harvard said, sure. If that's how they identify, then sure. Well, I think when you hear that and the justices hear that, then you realize this has gotten really silly.
I have a related, I hope, follow-up question. Is what Harvard's doing and all its peer institutions in their institutional self-interest? Is this carefully tailored discrimination in point of fact, increasing their portfolio, perpetuating their influence, and making sure that they stay successfully as a dominant institution in United States society for the indefinite future? And if it is in their self-interest, how do we alter their self-interest so that perpetual discrimination doesn't suit their self-interest?
Who wants that one?
I'll take the first swing. I'm sure the next two will be better. I don't think so. I think that Harvard might think that it is, but that's the result of artificial externalities. And the tough part of your question is, how do we alter that? I actually think that from a totally cynical perspective, I see what you're asking. I mean, if you talk to executives in the Ivy or even the Big Ten, they will say, well, I don't think we would get the same number of applications if our schools consisted 85+% of Asian engineering majors. That may be a terrible reflection on the latent racism of the country. I'm inclined to view it that way. I mean, this sounds like the discrimination against hardworking Jewish students that was discussed earlier. It sounds exactly like it to me. But I mean, nonetheless, that is something that if you were the provost of a university, you might take into account. But I don't think that what we're doing now with this sort of nearly proportional selection of people from a range of different racial groups using vague made-up criteria is particularly logical. I think that there are reasons for it, like the prevalence of very large DEI divisions within universities that sometimes sound like something that the political right is exaggerating, but that are very real. I mean, I did some research for my upcoming book on the University of Michigan's diversity office, old rival of my University of Illinois. It currently employs 109 people. I mean, all at solid 6 or 7 figure salaries. I mean, so when you've got that there, you have a really strong institutional interest in keeping these policies in place. I mean, it would be very easy to do something that would, class-based affirmative action is something we've already mentioned. How about 100-point advantage for hardworking people from within your state or something like that, if you don't want to be entirely dominated by one subset of competitors? All those things would be quite popular. They would make perfect sense. Get rid of athletics and let everyone compete for spots on the teams. There are a whole bunch of things you could do. We don't do those because they're entrenched institutional interests at work. How do you fix the problem? Get rid of those interests. How do you do that? Now, that's a real question.
I think it's a fascinating question as to what motivates university bureaucracy, because it's not what we would normally think of as market competition. And the reason I say that is because there's almost no innovation or different ways of doing things among a topic. Again, I'm going through this admission process myself with my 12th grader. You go to every college, we have 300 clubs. We have this diversity office. We have study abroad. I mean, let's say you were just to pick on, not to pick on Tufts, but let's say you're Tufts. You're never going to be Harvard, right? But you want to get to more like that level. You want to be just below Harvard rather than competing with all the other sort of not quite Harvard schools. Why is there no school like that? Not a single one who says, let's do something different. Let's announce that we're the one school that doesn't look at race. If you don't like that, come here. Maybe your minority student doesn't like the idea that you're being admitted partly for that. Or half of will still fill our football team and our track team and all that other stuff. But if you have over 1,500 in your SATs, we'll admit you with a 3/4 tuition scholarship. But you tell us by October 15th, so you can't apply anywhere else. You don't have to go through the whole admissions rigmarole. You go to an excellent school, you won't pay much. But there's no competition, there's no innovation. Everyone's doing the exact same thing. And it is, if I were an economist, this would be a fascinating thing to explore. Why doesn't any university president or any university bureaucracy say, the one way to succeed in this world, if you're in stasis, is to do something a bit different, and there isn't any.
Yeah, I think, David, Randall, you asked about, is it really in Harvard's self-interest to do this? And I think, what's in their self-interest changes over time, right? In the 1920s and 30s, it was, let's not drive away the Protestants. So it's in our self-interest to discriminate against Jewish applicants. And that lasted for a few decades. And for the last few decades, it's in our self-interest to perpetuate this diversity rationale, a rainbow of people, based on their race and national origin, and to espouse that. But that might be coming to an end, and they have to kind of adjust and decide what's now in their self-interest, and whether it's kind of wokeness that we see is hitting colleges and K through 12 schools and things like that. I think it shifts what's in their self-interest, so it might be shifting quite soon.
Thank you. I have a question where I also want to follow up from Maya Novakovsky. What if we followed the advice of Chief Justice Roberts and just stopped discriminating? I want to make that more specific. What would be the top 3 effects on undergraduate admissions and the character of undergraduate education if the discrimination regime came to an end? And I note this actually happened, and it wasn't just replaced by a proxy, as almost certainly will happen. But what would be the result if it actually came to an end and were enforced?
Well, look, this ties into the last question. One reason universities all do this stuff is because these are very expensive institutions. They're elite institutions. They're seen as tickets to success in American society. And it is unacceptable, I think, socially, to a broad swath of Americans, I wouldn't say 100%, but well more than 50%, to have an institution that's almost all white and will add today Asian. Why should that be? I mean, I have a quote going back to the 1980s where a well-known important professor at Berkeley in an article about affirmative action said, well, if we didn't have any discrimination against anybody, 80% of our students would be Jews and Chinese, as if this was like a terrible thing. I was like, well, what's wrong with Jews and Chinese? But there is this sense that because these institutions are so elite and so important, they must reflect our broad swath of society. So I think the answer is that we'll never get to the point in the foreseeable future where they're going to really not discriminate with no proxies, because going outside, for example, you could come up with all sorts of ways that you might make undergraduates more diverse. But I've done some research on this. Unfortunately, and I'm not a sociological expert to explain it, but the statistics, for example, in the LSAT for African American students are quite grim. And if you only looked at LSATs and grades and maybe extraordinary achievements otherwise, you'd have the top 20 law schools. That'd be a vanishingly small percentage of our, may have improved since I did the research, but still not a lot. And you can't really imagine in 2023, Harvard Law School, Yale Law School, Stanford, Columbia, Chicago, collectively having 1 or 2% African-American students, which would be the likely result. So I'm afraid that we're between a rock and a hard place. Even conservatives who I know who are strongly against affirmative action, if I tell them, would you be okay if 500 Harvard Law School 1Ls, that 5 to 10 of them were Black, and most of them sort of say, oh, well, there must be something else we can do. So until we get to the root of the problem, raise the achievement level of minority students to a point where we could get what would be seen socially as an acceptable level of minority representation without using discrimination or as proxies, I don't think we're going to get there, whatever the Supreme Court says.
Other comments on that?
Yeah, I mean, it seems like we've been alternating sequence. I agree with some of that. The test score point from David is just, so this is important enough to be worth dwelling on for a second. And I don't think a lot of people really know this. There are massive performance gaps on almost every standardized test. I am a culturalist. I don't think this is due to genetic differences in intelligence. I also certainly don't think it's due to racism. Brookings Institute came out in 2017 and very awkwardly suggested one possible explanation, which is that there were massive gaps in study time. So both African Americans and white Southerners study about half as much as Northern white kids, and those white kids study about half as much as Asian Americans. You can Google Brookings 2017, you'll find this Jewish Americans, Ashkenazi Jews specifically, study more than I believe anyone in the country. They were a little bit ahead of the Chinese. There's a close race there at the top. Indian Americans were up there as well. But I mean, to me, this explains whatever might be going on at the margins. This explains about 90% of what we see. But if we're just talking about raw performance, I mean, last I looked at SAT data, it was blacks, I think 951, American Indians about the same, like 960, Hispanics 987, so a big cluster there. Whites did better. Whites were around 1100, and then Asians were around 1200. So there was a massive dappling that perfectly matched study time rates. And I mean, the other two paradigms have their explanations as well. But this is a reality. So if you simply assign spots based on test scores, that's kind of what you'd see. The question is, would I have a problem with that? Like, as a black guy who leans at least a bit to the right, I'm not sure I would, honestly. So I think the first thing you would see to answer your question, Dave, is you would see dramatically different patterns of racial representation in elite schools. This wouldn't necessarily advantage whites, by the way. You would see a huge number of East Asians. You'd see a lot of Indian Americans. You'd see a lot, I guess Jewish Americans are mostly white. But by the way, for the black contingent, you'd probably see about 2 or 3% West Africans. You'd see virtually no black Americans. West Africans, by the way, would be represented about proportionately. There just aren't that many in the USA. So you'd see a diverse population, but a diverse population that looks nothing like the black, Hispanic, white pool we think of as diversity. That's the first thing. The second thing is that you would see a massive gain for the secondary schools. And this is the reason I might not be against this. I'd have to sit down if I were a local leader, some talk about it. But I mean, for example, at K-State, at schools where the average SAT is a 1200 or something like that, there are a lot of rock solid black students, Hispanic students, I mentioned Southern white students, that have 1200s. Those kids would no longer be going to Yale. They'd be going to, Western Kentucky. And I personally think that far more of them would get out with a degree and then an MBA. I mean, there are entire books about this, like Mismatch by Sander and Taylor. So, I mean, the first thing you'd see is a dramatic shift in elite university membership. By the way, if you did this really fairly, all the legacy George Bush whites would be gone too. No offense to anybody. But part two, you'd see a boost the HBCUs, the A&Ms, all those colleges you've almost forgotten that exist in towns with names like College or College Station. They would suddenly jump to number 97 in the rankings. I mean, you'd see some moves there. The real question ethically is, are we for that on the panel? And I'm going to give a lot of ambiguous, wishy-washy maybes. But I mean, there's a lot to be said. It's not fair that Harvard set a 15% bar for Jews. I mean, it's not. At a certain level, you have to say, if these are the best competitors, these people probably should be going to school. Harvard thinks that'll hurt enrollment for 5 years while people work things out. Harvard has an endowment of $70 billion. Harvard is a trust fund with a university attached. I think they'll make it. So, I mean, those are the results, and that is my opinion on the moral and logical efficacy of what we'd see.
Thank you. I am going to say it's 3:28 p.m. I am going to therefore ask for some concluding comments from each of you, no more than a minute, and then I'll just have some, concluding remarks, from the point of view of NAS. If I may, we'll just do alphabetical order this time, I think, if I may. David Bernstein, alphabetical order by last name. Would you be so kind as to go first for a last-minute concluding comment?
Sure. I would say that we should be restricting the use of racial classifications and ethnic classifications for all sorts of reasons that are fairly obvious, the dangers involved in having the government do this, unless the government could show a compelling interest in doing so, and that includes state universities. But if the government does have a compelling interest in using race in a particular context, we should at least be using racial classifications and racial categories that make sense given what the objectives are. So if no one really believes in the academy that the main objective of affirmative action is diversity, although the Supreme Court has forced them into it. They really believe, as Will said, that ultimately it was based on trying to bring African Americans into the economic mainstream, and particularly ones who are descendants of slaves and lived through Jim Crow and so forth. If that's the objective, there's no reason to include recent Hispanic immigrants and their descendants in it. There's no reason to include someone who's 164th Native American, and there's no reason to include immigrants and their children from Africa and the Caribbean. So we need two things. We need to have a sensible idea of when we want to use classifications, and we need to recognize the classifications we're using across the board, but in education as well, were just invented by the government, specifically with no intent for them to be used in affirmative action, specifically not to be used there, much less in the educational context. And if we are going to use them, there should at least be some sense in the way they're being used.
Thank you. Professor Reilly.
Yeah, I think building on that, my comment on this, as opposed to saying I'm against affirmative action in all situations or the reverse, I think that what I want to see in this discussion is more honesty. I think we need to be very honest about the test score gaps that exist between groups. I think we need to be very honest about what colleges are actually doing when it comes to admissions. The idea that we're following some sort of vague, holistic goals process here rather than a hidden quota, and at my alma mater, it's producing 10% Black, 11% Black, 10% Black, 11% Black every year is a joke. We need to be honest about mismatch effects and what's actually happening to a lot of those Black kids at Illinois or Michigan business and law school, much less the Ivies. And once the facts are on the table, we need to sit down and have a hard conversation about whether we're going to keep doing this. And if so, who are we going to involve in this process? Because I absolutely agree with Dave. There's no reason that the child of a foreign lord should benefit from any of these programs. No offense to him. So my 3 words would be honesty, honesty, honesty. And that's something that's missing from almost every American discussion of race and class, of course.
Thank you. And Jonathan Vogel.
Thanks. Really good points by my co-panelists, and it was a pleasure to be on a panel with you. I think that, in being honest about this, we need to look at K through 12 and proficiency there. That's where the focus is. Why are there disparities in college applicants and SAT scores and LSAT scores? That's where the focus is, so that we can have an honest conversation. I think as far as college admissions, I'd love to see the Supreme Court eliminate the diversity rationales of compelling governmental interest, because I don't think it's compelling, and I think it's been horribly misused and abused. And what I would love to see in the future is blind admissions. I'd love to see student applicants have an applicant number, and the college doesn't know their name and doesn't know their race and ethnicity, and judges them based on the merits of their application and all the other wonderful things that they bring to the table.
Thank you so much. Well, thank you all. And I'm just going to close with a bit of, housekeeping stuff. One, if you enjoyed this and you're not a member of the National Association of Scholars, consider joining the National Association of Scholars. We do lots of good stuff, including webinars such as this. We have different series. American Innovation is one series. Right Ideas on Conservative Thinkers is another. And continuing on race in higher education, our next one is going to be February 14th, From Affirmative Action to Diversity, Equity, and Inclusion. And that'll be followed by another one on February 28th, Neo-Segregation and the Institutionalization of Racial Preferences, and more throughout the course of 2023. I wanted to say again, if you have questions that are left over, you want to have them answered, please send email to me at randall@nas.org, RANDALL, and at nas.org. And I'll be delighted to forward your questions to our speakers so they can have the option to reply to you. I will say again also, we have recordings of this up within 24 hours at the National Association of Scholars YouTube channel. You will be able to see this, and indeed our entire library of fine video webinars available, for perpetuity. And I guess the final bit of housekeeping is to say thank you. Thank you to our panelists thank you to our audience. As you literally make this happen by the questions you provide. And it is, of course, for you that we are here and speaking at all. So a very great thank you, panelists, audience, everyone. Lovely to be here, and I have learned an enormous amount myself.
Thank you.
Thank you, David. Thank you, NAS. It's a pleasure.